A hospital in Michigan accidentally posts the medical records of thousands of patients on the internet. A health insurer loses the financial, health, and personal information of 450,000 customers and fails to notify them for 6 months. And 2 of the largest pharmacy chains in the U.S. are found discarding patient records and other legally protected information in unsecured dumpsters. This unnecessary exposure of private information should be alarming. In fact, since the creation of the HIPAA Act, the Department of Health and Human Services has investigated approximately 19,000 legitimate complaints of privacy violations. These statistics are simply unacceptable. As professionals who work in healthcare, how we protect personal health information is just as much a part of our jobs as the care we deliver. At stake is not only the privacy of the individual's care, but the security of personal information which could be used for medical identity theft and other illegal purposes. And as healthcare continues to adopt technology to coordinate patient care, such as electronic health records and computerized physician order entry, the need to protect electronic health information is becoming more and more important. In 2003, the Department of Health and Human Services began enforcing the Health Insurance Portability and Accountability Act, or HIPAA. Essentially, the HIPAA law protects the security and privacy of all medical records and other health information that is used or shared in any form, and protects patients' rights by giving them access to their health information and control over how it is used. In 2009, as part of the American Recovery and Reinvestment Act, also known as the Stimulus Bill, even more changes were made to the HIPAA privacy and security standards, including requirements for addressing breaches. And in 2013, the High-Tech Breach Notification Final Rule modified the privacy, security, and enforcement rules to strengthen privacy and security protections as provided for in the American Recovery and Reinvestment Act. There are certain businesses called covered entities that must follow the HIPAA rule. These include entities that provide or bill for medical care and services, such as hospitals, skilled nursing facilities, home health agencies, ambulatory surgery centers, and physician offices. Entities that pay for medical care or process health information in order to conduct financial and administrative transactions, such as a health plan, healthcare clearinghouse, or a claims processing or billing company. And their business associates, such as third-party administrators, a health information exchange organization, or e-prescribing gateway. HIPAA is a federal law, so compliance is not voluntary, it's mandatory. And ignorance of the law is no defense. As an employee of a healthcare facility, you must become aware of your role in protecting the privacy and security of your patient's health information, or subject yourself and your facility to dire consequences. Anyone that obtains or discloses protected health information for personal or commercial gain, for malicious purposes, or by willful neglect is subject to termination, suspension, and criminal and civil penalties, including jail time and fines ranging from $100 to $50,000 or more per violation. Before we can explain the HIPAA privacy and security standards and how we are expected to follow them, it's important to understand some basic definitions. HIPAA is specifically concerned with protected health information, or PHI, which is defined as information that relates to the health of an individual, the health care provided to that individual, or payment for health care provided. PHI is protected whether it is spoken, electronic, or written. PHI includes information that can be used directly or indirectly to identify an individual, such as name, address, birth date, social security number, or medical record number. The bottom line is that any information that relates to a patient's health cannot be disclosed or shared unless authorized either by the patient or someone acting on the patient's behalf, or unless permitted by HIPAA regulation. Additionally, the facility must limit access to only those individuals who need the information for a legitimate purpose. For example, an insurance company may need to access private information in order to pay a claim, but they cannot share this information with the patient's employer. PHI can also be used by a business associate, such as a patient safety organization, to create, receive, maintain, or transmit PHI on an entity's behalf, as long as there is a business associate agreement ensuring the information is safeguarded. The doctors or nurses in a hospital who are involved in the direct care of a patient need complete access to all the medical records of a patient in order to provide the best care possible. But a lab worker processing the patient's tests would not need full access, since this information is not vital to evaluating the tests. This nurse used her position to access a co-worker's health record and is gossiping about the results. Since this nurse is using private medical information for the personal and malicious purposes, she is in clear violation of HIPAA regulations. The nurse could be suspended or terminated by the hospital. HIPAA standards state that when information must be shared, it should be limited to the minimum necessary. In other words, the least amount of information necessary to accomplish the purpose of the request. For example, to report a suspected case of child abuse to Children's Services, you would provide only the specific things they need to know, such as dates the child was admitted or treated, and the relevant information as to why the abuse is suspected. A nurse could ask outside clergy to visit a patient, but can only mention that the patient is going in for heart surgery if the patient has been informed of this use and disclosure and does not object. However, the minimum necessary does not apply to the sharing of medical records among healthcare providers for treatment purposes. There are no restrictions on the use of de-identified health information, which neither identifies nor provides a reasonable basis to identify an individual. This means removing name and address, date such as birth date or date of care, telephone and social security numbers, even device serial numbers and other identifiers from a record, so that it is no longer protected health information. Another way to limit access to PHI is to hide it from plain sight. For example, under the HIPAA rule, sign-in sheets that require a patient's name and medical complaint may be a violation of privacy. The sign-in sheet provides individually identifiable health information that is accessible to anyone that signs in or looks at the log. Many facilities ask patients to fill in single sheets, or at least limit sign-in sheet information to name and time of arrival only. Or facilities may choose to use barcodes to identify patients once they are admitted. In addition, patient information must not be handled in a way that puts this information at risk. By leaving a patient's medical record on the counter, it is easily obtained by anyone and is no longer protected. Medical records should be made accessible only to those that need access to them, and when not in use should be maintained in a secure manner that restricts access with locks or requires records to be signed in and out. Computer screens should be positioned away from general access areas and have passwords or access codes that are changed frequently. Be sure not to post your access code or make it available to others, and log off your computer when not using the software. Remember too that HIPAA protects private health information that may be overheard. By using a public area to share news with a family member and talking loudly, this doctor is not making a reasonable effort to discuss private medical information away from others who may overhear. Ideally, family members should be invited to a more secluded area where they can talk with providers in a confidential setting. And finally, when there is no longer a need for the personal health information, it must be rendered unusable, unreadable, or indecipherable, either by encrypting or purging electronic PHI, or destroying the media on which the PHI is recorded or stored. Remember, it is often the simple things we do on a daily basis that are the most important in safeguarding the privacy and security of a patient's information. Be sure you are aware of the protocols that relate to your position and keep them top of mind every day. Because we are all involved in the care of patients in one way or another, You should also become fully aware of the many patient rights under HIPAA. To begin, patients must be given a summary of their rights, as well as a clearly written explanation of how the facility may use their health information, such as for treatment purposes or for payment. There must be a good faith attempt to obtain a patient's written acknowledgement that they have received the notice of privacy practices. Be sure to plan for alternative methods of relating this information, such as a language line or translator if the patient cannot read or speak English. Patients have the right to access their medical records in order to view and copy them in either print or electronic format, and they must be made available within 30 days of a written request. Now, there are exceptions to the right of access, and these include psychotherapy notes and information that is being compiled for use in legal action. Patients have the right to request a free accounting every 12 months of how their health information has been disclosed for treatment, payment, other healthcare transactions, or for other reasons such as a court order. Patients have the right to amend incorrect or incomplete information in their records. However, if the facility believes the information is correct, they can deny this request, and they must provide the patient with a statement of disagreement. If a patient pays out of pocket for medical services, they can request that the information about that service not be disclosed to the health plan, and entities must comply. The new rules make it easier for parents to authorize the disclosure of child immunization proof to schools. A patient must be given written or verbal notice and opportunity to opt out of the patient directory, which allows for certain information to be disclosed if a patient is asked for by name. If the patient consents to being listed in a patient directory and an inquiry is made, healthcare personnel can only confirm the presence of the patient, state her condition, and give information on where she is located unless the patient requests otherwise. If the patient does not want to be listed in the directory, this must be documented so that the person providing the information is aware of the patient's desires and cannot confirm or deny that the patient is in the facility. There is no requirement to verify the identity of a person requesting information contained in a patient directory. However, anytime a request is made for personal health information, you must take reasonable steps to verify the requester's identity and authority. This includes family members asking about the patient to insurance company representatives investigating a claim. A reasonable effort must be made to allow the patient to authorize information to be given to family and friends. For example, patients can request that the facility deny information to family or friends, even if they are involved in the care of the patient. As with any privacy request, be sure to document this request in their records. However, it's important to note that the new rules now allow entities to release the PHI of deceased individuals to family members and others if they were involved in the care or payment for care of the decedent prior to death, unless doing so is inconsistent with any previously expressed request by the patient. If there's reason to suspect that a patient's injuries are the result of domestic violence, you do not have to disclose any information to the spouse. If there is any suspicion of abuse, the facts surrounding the injuries and the request for information should be carefully documented. In addition, unless the patient gives either verbal or written permission, he or she can request that information, including access to the patient's medical record, be withheld from the spouse. Patients must give authorization for the use or disclosure of PHI that is not for treatment, payment, or healthcare transactions. And patients can request reasonable restrictions on how this information is shared. And this must be stated in the Notice of Privacy Practices. For example, if a patient is injured in an auto accident, she must give authorization for her medical records to be released to her personal injury attorney. Patients must authorize communications for fundraising purposes as well as uses that constitute the sale of PHI. Authorization must also occur for all communications associated with marketing a health-related product or service via telephone, mail, or email conversations. The exception is marketing through face-to-face communication, For instance, a healthcare professional may recommend a specific product with a sample or pamphlet even if they receive financial compensation for promoting the product. Patients should also be told that their personal information may be disclosed for certain other reasons without their written authorization, such as mandatory reporting to health departments or to report abuse or neglect. In addition, facilities do not need authorization in order to release private medical information to law enforcement if requested by warrant, summons, a court order, or subpoena. Subpoenas require a waiting period in order to give the other side an opportunity to object to their release. This time period is usually set by the state. Law enforcement requests must be relevant to a legitimate law enforcement inquiry, such as to identify or locate a suspect or to request information about the victim of a crime. Patients should be made aware that the Genetic Information Non-Discrimination Act prohibits most health plans from using or disclosing genetic information for underwriting purposes. Lastly, patients have recourse if their rights are violated. If a patient feels their information was shared inappropriately, they have the right to file a formal complaint with either the facility or with the Office of Civil Rights, which is a division of the Department of Health and Human Services. In addition, the new security requirements state that if there has been a breach of personal health information, individuals and the Department of Health and Human Services must be notified. Breaches include the unauthorized acquisition, access, use, or disclosure of PHI which compromises the security or privacy of that information. And if 500 or more people are affected by the breach, the local media must be alerted. Remember that all breaches to privacy and security are potentially damaging and should be considered unacceptable. If you suspect that there has been an actual or attempted security breach to any form of protected information, whether it is electronic, paper, or recorded, report to the correct authorities according to your organization's policy, and report any violations of confidentiality immediately to the privacy officer. The fact is, in the healthcare environment, ensuring the security of private medical information is everyone's responsibility. Failure to do so can have many consequences, to you personally, to your facility, and to the patients who have entrusted you with their care. Be sure that you are taking part in HIPAA training and become knowledgeable about patients' rights and your role in protecting them. Your facility's compliance with HIPAA regulations ultimately comes down to you.